this is a question that needs to be answered.
Grant Robertson.
Very much, Mr. Chair, and I do want to pick up off Mr. Mark's contribution, who should have become a lawyer, judging on that contribution. He could defend himself from time to time as well, which might help. But I believe his analysis was spot on, and I do thank the Minister for answering the questions that were raised, because, as Mr. Mark noted, she did that genuinely on the basis of the advice she got from officials. But there is an issue here, and it does require us, Mr. Chair, to look at the substantive piece of legislation that's been amended, the Local Government Auckland Transitional Provisions Act. And that establishes, beginning at clause 128 and running all the way through to clause 150, how the hearings panel will work. And the problem for the advice that the Minister gave us is that there is only one type of hearings panel. There isn't a different range of hearings panels, yeah, something like that. There isn't such a thing in law as a site-specific hearing panel. So that's what the Minister said. She said there would be decisions made about whether there would be 3 or 2, as clause 4 of this bill allows for, 3 or 2 members on that on a site-specific basis at the discretion of the chair. There is nothing from clauses 128 to clause 150 to create that. There is simply a thing called a hearings panel. So if that is the case, the hearings panel then has to do all of the things that the Act asks, which, as Mr. Mark has just told us, under clause 144, well, in fact, the title of clause 144 is, hearings panel must make recommendations to Council on the proposed plan. So it doesn't have an option. So if there are 2 people at a site-specific meeting where we don't know who the chair necessarily is, that group of 2 people are obliged by the law to make a recommendation. So with respect to what the Minister has told us, it's simply not the case in law. It may be the intention of the officials or the intention of the government to create a situation where a panel of 2 wouldn't make a recommendation, but the problem is that's not what the law says. So Mr. Mark's original question, asked now nearly 2 hours ago, still stands. The original question stands: what do we do when there are 2 people serving as the hearings panel who disagree about a recommendation? And that's quite possible. That it remains quite a possible situation. Under the law, under clause 144, even as amended in clause 5 of this bill, they will be obliged to make a recommendation. So I ask the Minister again to stand up and explain to us how, in fulfilling their role under the law, a hearings panel now potentially made up of 2 people will resolve a conflict, because Mr. Mark's question stands. I understand the practice that the Minister believes will now take place, but that's not the law. And a hearings panel of 2 who fail to make a recommendation on the proposed plan will be in breach of the law. They'll be in breach of section 144 of the law. This is the difficulty caused by moving from 3 to 2 as the quorum. And we haven't had an adequate explanation as to how the law will be fulfilled. I think the Minister might be able to get further advice about that, because I suspect that the officials have talked about that, and I'm happy to give a bit of time for the officials to have their conversation about this. Well, my colleague Dr. David Clark suggests a coin toss. I think Aucklanders deserve better than that. I think Aucklanders actually deserve to know how this will work. And we understand that's why parties in this House, with the exception of our colleagues in the Greens, are supporting the principles of this legislation, because we know that the unitary plan process needs to speed up. We know that there needs to be a more efficient process. But what we can't be doing under urgency is passing law that is contradictory. Because we'll be back yet again saying, oh, hang on a minute, actually, we don't want a hearings panel of 2 to have to make a recommendation, because what if they can't? What if they can't agree? So perhaps there does need to be an additional clause that says that exactly what the Minister told us in her intervention, that if there is only 2 people, it's site-specific.
Calling